Count 28 is trying to convert ordinary litigation procedure into procedural obstruction. On its face, it's conclusory and derivative. Let's dissect it directly. Number 28, routing directive and communications bottleneck. Open quote, the specific routing directive, resulting communications bottleneck, and the procedural obstruction and deterrence. Close quote. Number 1, what routing directive? Unless Count 5 identifies a written county order prohibiting plaintiff from filing documents, a directive blocking statutory filings, an instruction preventing access to a clerk, court, or public office, a policy uniquely imposed on plaintiff outside normal litigation practice, then the likely routing directive is simply, open quote, all communications must go through the county attorney's office, close quote. If that's the case, that is standard litigation control once a party sues the county. That is not obstruction. That is legal protocol. 2. Communications restricted to AROD's office. Correct and expected. Once a party files suit against a government entity, staff are typically instructed not to communicate directly. Informal back-channel communication stops. Discovery and requests proceed formally. Counsel becomes the point of contact. That is not punishment. That is risk management and attorney-client privilege protection. Courts do not treat centralized communications during litigation as constitutional violations. Just 3. What communications? For this to survive scrutiny, plaintiff would need to identify dates, specific requests, specific denials, a statutory entitlement to the requested information, harm caused by delay or refusal. Saying communications were bottlenecked without specifying what was requested, how it was blocked, why it was legally required to be provided outside litigation is insufficient under pleading standards. If the communications relate to discovery must go through rules of civil procedure, public records governed by open records statutes, court filings handled by the court clerk, not the county attorney, administrative assistance typically suspended once adversarial litigation begins. Without identifying a denied legal right, the allegation remains rhetorical. The structural weakness Count 28 depends entirely on Count 5. If Count 5 does not establish a legally protected right, an improper directive outside litigation norms, retaliatory motive, denial of court access, then Count 28 collapses with it. Saying we have written communications does not fix the problem unless those communications show unlawful conduct. What would actually constitute obstruction? To rise to constitutional or actionable misconduct, plaintiff would need to show something like refusal to accept court filings, threats for filing motions, blocking statutory public record requests, interference with service of process, misrepresentations to the court, direct retaliation for exercising legal rights. Nothing in your summary indicates that. Bottom line, based on your points, the routing directive appears to be standard counsel centralization. A communications bottleneck during active litigation is routine. No specific denied right is identified. No specific obstructed communication is identified. As written, this reads as dissatisfaction with adversarial procedure, not procedural deprivation. If you want, next I can assess whether the cumulative theory, counts 23-28, could plausibly frame an access to courts claim under Section 1983.